Welcome to Millens TV. Ross, as I move around amongst my business colleagues and friends, I hear them talk about trusts a lot. And they often ask me, what is a trust?
What is a trust? Well, I recently had to explain to some people from overseas who had no idea what a trust was. I said, it's very simple. It's just a body of rules that sets out how one person, the trustee, holds property, assets or a business, whatever it is, on behalf of other people, the beneficiaries. So it's just a set of rules. It's like a contract, it's an arrangement, how one person who's registered as the owner of the property is going to hold it on behalf of others. Now that's very simple, but there's a whole lot of different types of trusts. There's discretionary trusts where the trustee has a very broad discretion as to who they're going to pay the income to, who they're going to pay the capital to. You have unit trusts, which are a little bit more like a company where everyone has a fixed number of units and they know what their share is going to be. And then you can have things called hybrid trusts, which are a mixture of both. You might have different classes of units, the units having different rights, and the trustee having a discretion how to treat each class of unit holders quite differently. So the trustee has a lot of discretion, can make a lot of decisions about how these assets and businesses are going to be held and dealt with for the beneficiaries.
The trustee really has all the power, and I have to trust the trustee to do the right thing by me.
Yeah, can you trust the trustee?
Well, that's the $64 question. What happens if I don't trust the trustee and I want to challenge a decision made by the trustee?
Well, what we've found is that it's actually very difficult for beneficiaries to successfully challenge decisions made by trustees. So rule number one, be the trustee.
That's a great idea.
Rule number two, have control over who is the trustee. But there have been some recent situations that we've seen which are quite, I was quite surprised with some of these results. But one we saw was where a beneficiary, clearly a beneficiary of a discretionary trust, was a bit concerned that maybe the accounts weren't being properly kept by the trustee. So they quite rightly said, can we have a copy of the accounts, please? Very simple request.
Simple request.
I think there was no problem with that.
Did they get them?
No, because before they were given them, the trustee had a power under the trustee to remove beneficiaries as beneficiaries. So the trustee resolved to remove that person as a beneficiary and then said, oh well, you're no longer a beneficiary, you can't have the accounts. Now this led to a court case where the beneficiaries said the power to remove me had been exercised improperly. It was only done to remove me because I asked for the accounts. Now what the trustee said to the court was, oh no, we thought that person and their side of the family had no more interest in this trust. There was a deal done years ago that we thought they were all out. So the reason why we exercised that discretion was just to give effect to what we'd already decided years ago. Nothing to do with asking for the accounts. And the judge said in the absence of any other evidence, that was the case. So couldn't get the accounts. Very odd.
Very disappointing.
Now, and another one that we've also seen is a reported case. And what happened here was that it was a unit trust. The trustee decided that there were a few minorities there. They would redeem their units at a fair value, but obviously the unit holders didn't think that was the right price. They were being underpaid. And they went to the court and they said, we came into this investment for the long term. It's only been a few years. We want to stick around. We want to get the big payday in a few years' time. What did the judge say? Well, there's no unit holders agreement. There's a few emails about long-term investment, but what does that mean? I can't upset the trustee's decision under the trust deed, which says they have absolute discretion to redeem units from time to time. And as long as it's at fair value now, there's no need for them to wait. So again, these beneficiaries missed out, probably in that case because they hadn't taken the time to have a proper unit holders agreement. but it did show that it was extremely difficult for them to try and set aside in the court the decision that the trustee had made under the unit trust deed.
So Ross, I don't need to be Gina Reinhardt or a member of her family to have issues with a trust or a unit trust or a family trust, but what are the key messages for people who are involved in what we see so often in corporate Australia, trusts?
Well, trusts are very useful for tax and other reasons, so don't be scared of them. But the main thing is that if you are in a minority position or you don't control the trustee, make sure you have a very, very clear unit holders agreement in a unit trust, or some other similar type of, as we previously said, relationship agreement, or make sure that your rights under the discretionary trust are very, very clearly set out, either in the trust deed or some other document that's binding on the trustee and the other principal beneficiaries. Because if you don't, you might find that decisions about very valuable assets will be made by the trustee without any reference to you, quite against your wishes, and you're not going to have a right to challenge it. So that's this month's message.